If you are over 60 and you have not heard about this yet, stop everything you are doing right now. Because in the last 72 hours, something happened inside the United States Supreme Court that directly affects your Medicare, your Social Security check, your prescription costs, and your legal rights as an older American. And the number that tells you everything you need to know about how significant this is 8 to 1. 8 justices agreed, 1 dissented. That almost never happens. When 9 people who disagree on virtually everything look at the same situation and 8 of them land in exactly the same place, that is not a close call. That is a statement, and the statement they just made is about you. My name is Ray, and this channel exists for one reason: to make sure the information that affects your money, your health, and your future reaches you in plain language before the deadlines pass. Because here is the truth about this ruling that nobody on cable news is explaining clearly. The Supreme Court did not send you a check. It did not automatically enroll you in anything. What it did is far more powerful and far more urgent at the same time. It confirmed that a sweeping set of protections for older Americans are now constitutionally locked in, and many of those protections require you to take action. Some have windows, some have deadlines, and the senior who acts in the next 30 days will be in a fundamentally different position than the senior who watches this and moves on. Subscribe right now and hit the notification bell, because what I am about to break down affects every single person over 60 in this country. Let us get into it. First, let me tell you exactly what the Supreme Court ruled and why it matters more than anything you have heard about senior benefits in years. For the last several years, a sweeping piece of legislation called the Elder Care Protection Act has been working its way through implementation across the country. It covers prescription drug pricing, it covers Social Security adjustments, it covers nursing home accountability, it covers elder financial fraud protection, it covers your right to stay in your own home as you age. And from the moment this law started moving, industries with billions of dollars at stake started fighting it in court. Pharmaceutical companies, managed care organizations, nursing home chains, financial groups. They filed challenges in federal court after federal court trying to delay, weaken, or eliminate the provisions that threatened their profits. 8 justices just shut all of that down at once. In a single sweeping ruling, the Supreme Court upheld and strengthened the full framework of the Elder Care Protection Act and closed every loophole those industries were counting on. The one justice who dissented did so on narrow procedural grounds, not on the substance of your protections. The 8-justice majority opinion was clear, broad, and built in a way that makes future challenges extraordinarily difficult to win. This is not a temporary victory. This is constitutional protection that changes the legal landscape for older Americans permanently. Now let us talk about what this actually means for your life. Starting with the change that has pharmaceutical companies in a panic right now: prescription drug costs. If you are on Medicare and you have ever stood at a pharmacy counter and felt that gut punch when you heard the price of your medication, this section is for you. For decades, Medicare was legally prohibited from negotiating drug prices directly with pharmaceutical companies. The largest buyer of prescription drugs in America was banned by law from using its purchasing power to bring costs down. Private insurers could negotiate, the VA could negotiate, but Medicare, which covers over 67 million Americans, could not. The result was that American seniors were paying 2, 3, sometimes 5 times more for the exact same medications that people in other countries were getting for a fraction of the price. There were 11 separate legal challenges working through federal courts trying to gut the Medicare drug price negotiation provisions before they could fully take effect. With this 8 to 1 Supreme Court ruling, every single one of those challenges is finished. Not delayed, not sent back for reconsideration, finished. What this means for you practically: if you are currently spending $200, $300, or $500 a month on medications for diabetes, heart disease, high blood pressure, arthritis, or high cholesterol, those costs are now on a legally protected downward trajectory. The annual out-of-pocket drug cost cap for Medicare beneficiaries is now constitutionally confirmed. There is a legal ceiling on what you will pay for medications in a single year, no matter how many prescriptions you fill. For millions of seniors who have been choosing between pills and groceries, this is not a small adjustment. This changes the math of retirement. What you need to do right now: call your Medicare Part D plan and ask specifically how the new negotiated pricing affects your medications. Ask what your confirmed out-of-pocket maximum is for 2026. You may be overpaying today without knowing it because your plan has not proactively told you what changed. Now, let us talk about Social Security because this is the section that will make a lot of you angry, and rightfully so. Every year, the Social Security Administration adjusts your monthly benefit to account for inflation. This is called the COLA, the cost of living adjustment. It sounds fair. It sounds protective. But here's what they were not telling you. The inflation formula they have been using does not track how seniors actually spend money. It tracks how younger urban wage earners spend money. Gasoline, electronics, work expenses, commuting costs, things that have almost nothing to do with your budget looks different. You spend more on healthcare, more on prescription drugs, more on in-home assistance, more on utilities. And those categories rise in price faster than almost anything else in the economy. The result has been that seniors were technically receiving inflation adjustments every year while quietly losing purchasing power every single year at the same time. The Elder Care Protection Act pushed to change the inflation formula to one specifically designed to track how seniors spend money. Industry groups challenged this in court, arguing it exceeded congressional authority. The Supreme Court, in an 8-1 decision, ruled that it does not. The Senior Specific Inflation Index is constitutionally sound and legally required to be implemented. This means your annual Social Security adjustment will finally start reflecting what your life actually costs. Over time, this can mean hundreds of extra dollars per year in your pocket. On a fixed income, a more accurate adjustment compounding year after year adds up to thousands of dollars over the course of a decade in additional benefits you were previously being quietly denied. What you need to do: log into your My Social Security account at cesa.gov and verify your current benefit statement. If you have not created an online account, do it this week. Check for any pending actions required on your account. And if you believe your adjustments have not been accurate, contact the Social Security Administration directly and request a formal review. Now let us talk about nursing homes, because this part of the ruling does not get nearly the attention it deserves, and for millions of American families, it is the most personal issue of all. The reality of nursing home care in America has been a quiet crisis for a long time. Chronic understaffing, safety violations treated as minor expenses, inspection reports buried where families could not easily find them, and in the worst cases, abuse and neglect happening to the most vulnerable people in our society while their families had almost no legal recourse. Nursing home industry groups fought the new staffing mandates and penalty structures in court, arguing they were economically burdensome. 8 justices looked at that argument and said no. Minimum caregiver to resident ratios are now legally enforceable. Penalties for safety violations are increasing dramatically, and repeat offenders now face the possibility of losing their Medicare and Medicaid funding entirely. For most facilities, that is a financial death sentence, and they know it. Transparency requirements are also now fully enforced. Every nursing home receiving Medicare or Medicaid funding must make its inspection reports, staffing levels, and violation history publicly accessible. When you are researching a facility for yourself or for a parent, you will see the real record. Not the glossy brochure, not the carefully managed tour, the actual documented history. What you need to do: if you have a loved one in a care facility right now, visit Medicare.gov and use the nursing home comparison tool to pull their updated inspection report. If you see something concerning, you now have stronger legal standing than ever before to demand accountability and to escalate. Let us talk about elder financial fraud, because this is a silent epidemic that is stealing billions of dollars every year from American seniors and getting worse, not better. The phone calls pretending to be the IRS, the Medicare scams, the investment schemes, the romance scams targeting widows and widowers, the contractors who take a deposit and disappear, and tragically, in too many cases, family members or caregivers exploiting access to a senior's finances. These are not rare edge cases. These are happening in every community in this country every single day. Financial institutions had challenged mandatory fraud reporting requirements, arguing they imposed excessive compliance burdens. 8 justices rejected that argument completely. Banks and credit unions are now legally required to flag suspicious transactions on senior accounts, and they have both the mandate and the legal protection to act on what they see. Sudden large withdrawals, multiple wire transfers to unfamiliar accounts, new names appearing on elderly customers' accounts. These are now required to be flagged and reported. Federal funding for elder fraud investigation and prosecution is also now fully confirmed and increasing. More investigators, more resources for victim recovery, stronger coordination between agencies. What you need to do, call your bank this week. Ask what elder financial protection protocols they have in place under the new requirements. Set up account alerts for any significant transaction. And write this number down right now. The National Elder Fraud Hotline, 1-833-FRAUD-11. Keep it somewhere accessible and share it with every senior you know. Now, here is the section that most news coverage completely misses. Home modification assistance and aging in place. Your home is likely your largest asset and the center of your life. The ability to stay in your own home and your own community, surrounded by your own memories as you age, is something almost every senior wants. But our homes were not built for the later stages of life. Stairs become dangerous. Bathrooms without grab bars become accident zones. And modifications can cost thousands of dollars that fixed income seniors simply do not have. Home modification assistance programs were legally challenged on funding grounds. The Supreme Court upheld the full structure. Eligible seniors can now access financial help to install ramps, widen doorways, add walk-in showers, improve lighting, and make kitchens accessible. These are not luxury renovations. These are the modifications that keep you safe, independent, and out of a care facility. When you consider what nursing home care costs, keeping seniors safely at home through modest modifications is not just compassionate, it is economically rational for everyone. What you need to do, contact your local area agency on aging. You can find yours at eldercare.acl.gov. They can connect you with both federally funded programs and state-level resources that may be available specifically in your area. Now, before this video ends, I need to say something that is more important than any single benefit I have described today. This ruling is the legal foundation. You still have to do the building. The Supreme Court confirmed these protections are real and legally enforceable. It did not automatically enroll you. It did not send you a letter. It did not update your account. Many of these benefits require an application. Some require you to update your information. Some have enrollment windows that close. The senior who picks up the phone in the next 30 days will receive benefits that the senior who waits will miss entirely. That is not speculation. That is how these systems work. And one more thing. Within hours of any major Supreme Court ruling affecting seniors, scammers are already working. Right now, today, someone is calling seniors telling them they need to pay a processing fee to receive their new benefits. Someone is sending emails claiming to be from Medicare or Social Security asking you to verify your account. Legitimate government services are always free. The Social Security Administration will never call you demanding immediate payment. Medicare will never ask for your credit card number over the phone. If you did not initiate the contact, do not provide personal information. Hang up. Close the browser, call the official number directly. Here's your action list. Call your Medicare Part D plan about negotiated drug pricing. Log into sa.gov and check your benefit statement. Pull your nursing home's inspection report at medicare.gov if you have a loved one in care. Call your bank about elder fraud protection protocols. Contact your local area agency on aging about home modification assistance. And write down the elder fraud hotline. 1-833-FRAUD-11. 8 justices just stood up for you. Now you need to stand up for yourself. Subscribe right now, turn on notifications, and share this video with every senior you know because the benefits exist, the protections are now constitutional, and the only thing standing between any older American and what they are entitled to is knowing they need to ask for it.